We have an update. Cop who killed a Black mother and her unborn child. He was charged with murder, has now been acquitted. We have the details. I'm taking you to the video. Here it is.
I take the 29-3705 Managua, 3705. A female is hallucinating. Too much of a lot to repent.
Out of the car. Out of the car. Out of the car. Out of the car.
Panic 7 in service.
Out of the car.
Panic 7 back in service. 1828.
Get out of the car. Then get out. No. Then get out.
Get out of the car.
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 Shots fired.
Shots fired. Stop the goddamn car. Stop the goddamn car.
We're going to have a 34 on the cop coming out. He's going to be out.
This is a tough one. Put up the cop full mask. This is a tough story. Sad. Beyond belief. A cop killed a Black mother and her unborn child. The cop is charged appropriately with murder. Cop Connor Grubb fatally shot the pregnant Takia Young in her car. In an update, a jury found the Ohio cop Connor Grubb not guilty of murdering Miss Young and her unborn child. According to the AP, the Blendon Township police officer was charged with murder, was also charged with involuntary manslaughter, and charged with felonious assault. Grubb potentially faced life in prison had he been found guilty of the charges. Franklin County Common Pleas Judge David Young dropped 4 of the 10 counts that related to Young's unborn child, as prosecutors did not provide proof that Grubb knew Young was pregnant when he shot her. Reminder of what led up to the shooting. August 24th, 2023. Officer Grubb and Sergeant Eric Malnihan responded to a call by a Kroger employee who accused Miss Young of shoplifting several bottles of alcohol. Young was in her car when Officer Grubb and the other officer arrived. Both officers approached Miss Young, demanded that she get out of the car. Young lowered her window and argued with the officers as they yelled and cursed at her to get out of the car. At one point in the body cam footage, she can be heard saying, quote, "Are you going to shoot me?" End quote. Grubb was standing in front of the car with his gun drawn when Young turned her signal on and slowly rolled her car to the right. This was to avoid hitting an officer. Grubb responded by shooting Young in the chest, killing her and her unborn child. There's more to this story that I'm going to give you. Now, in the United States of America, you are innocent unless you are proven guilty. So remember, they are dealing with an innocent person. In any scenario, regardless of if the alleged is true or not, nobody dies over a bottle of alcohol. What cop should be empowered to shoot and kill someone for allegedly making an unwise decision? And I'm reminded, before people moralize against this woman, I'm reminded of something in my old hood on Glenwood Road when I was a foster kid. I remember being paid money because I didn't have food to eat to go into a local store and steal alcohol for the adults who would pay me money for that so that I could have something to eat. So let's be clear about what happened. Somebody is dead because a cop decided to shoot rather than to step aside. You have information. You got the license tag number. You obviously can pursue if you choose to. It's a theft, likely not over a certain amount, which wouldn't even make it a felony. You're talking about a misdemeanor. And you still don't know for sure that this is the person who did anything. Now, on August 24th, they responded to this. A jury was shown a body cam. But what happened on August 24th, 2023? And heard testimony from police use of force experts and accident reconstructionists, and from the sergeant who responded. Grubb himself never testified, with the jury being given this his side of events through a written testimony. Now, we're going to get to that. Quote, "It's not right," Nadine Young, Takia's grandmother, said before she was escorted out of the courtroom. He's walking away free. It's not right. Nadine is now the primary caregiver for Takia's 8-year-old and 5-year-old sons. Now, I want to bring your attention to the jury, with the jury being given his side of events through a written testimony. The jury was given the cop's side of events via a written testimony. Objection, hearsay. Why? Because there's no opportunity to provide rebuttal, to provide cross-examination of the evidence being examined. What is the evidence being examined? The witness testimony. Why can you not provide cross-examination? Because you allowed a person to give a statement to the facts without testifying to the facts. Where did they do that at? I'm no legal scholar, but I went to law school. We learned 101. You don't do that. There's no cross-examination. There's more. Quote, "It's also heartbreaking because what it does is it normalizes the behavior like that Connor Grubb exhibited that day, and that it is not normal." Sean Walton, an attorney for the Young family, told reporters after the verdict was announced, quote, "If you look at these recent police killings in Columbus, you have officers who have an irrational fear with no weapons involved, or folks doing very minimal behavior that they escalate into a murder. That's exactly what happened here." Defense attorney Mark Collins said that while Grubb and his family are relieved by the verdict, it is wrong to presume he was unaffected by the shooting. Quote, "For the rest of his life, he has to deal with this," Collins told reporters. "Trust me, you didn't get to hear from him because the government put his statement out. But he took a life on duty and realized another's life after the fact. And to walk around with that is a difficult situation," end quote. Takia Young's family sent a statement to ABC News announcing that they intend to file a civil lawsuit against Connor Grubb. Quote, "Our civil case will prove that what the jury could not find beyond a reasonable doubt." The family said in their statement, quote, "We will show that Grubb created the danger by positioning himself in front of a vehicle with his weapon drawn." The family filed a federal lawsuit against Connor Grubb earlier this year. The evidence is also weighed differently in a civil trial. It is a preponderance of the evidence, preponderance of the belief, rather than the reasonable doubt scenario. Preponderance of the evidence becomes the legal standard. All right, Senator, thoughts here?
Yeah, it's a lesser standard. I was hoping they were going to go civil. I mean, this is shocking to watch, no matter how many times you see it. Officers are trained to also de-escalate
Right.
a situation as well. And in this situation, at least from the angles we could see, this was that kind of situation that could have and should have been de-escalated. Your point about you got her license plate number, just hold out. Can you hold out 5 more minutes, 10 more minutes? 50? What is she gonna do? Flee the city or flee the state? And this was a total miscarriage of justice, as far as I'm concerned. It is just it's just gut wrenching to come. Why you got your weapons drawn though?
Right.
And it reminds me, George Floyd in May of 2020. choked out by a knee of a police officer for allegedly a counterfeit $20 bill. Was it worth it? Was it worth it to do that? And Eric Gardner in New York, remember, he got choked out, totally choked out. The officer climbed up on his back and choked him down to the ground for some loose cigarettes.
Yeah.
And now I'm telling you, Doc, this is just stunning. I don't know what this jury saw. And Doc, why the prosecutor failed here? That's what I'm
absolutely.
thinking. Okay.
Absolutely, the prosecutor failed. The prosecutor failed. The fact that the judge was able to throw out the death of the unborn because the prosecution did not present evidence that the officer was aware that the woman was pregnant is really a non-factor. You don't have to be aware. You can be charged under the negligent form. Criminal negligence should have been attached. We don't see an effort for that to be attached. Also, an appeal should have been made then by the prosecutor that this judge has illegally thrown out credible charges that the grand jury has already decided. And a judge has thrown it out. That should have been appealed immediately, and that trial should have been stopped there until that was determined. So there are some other mistakes I believe happened, but those are some on face value.
And Doc, what about the officer not testifying? I just played a lawyer on TV. I ain't the real one, but
so this is a really interesting dynamic. The only time that I've heard of something like that ever happening, and even then it's questionable, is when both the prosecution and the defense agrees to it. I give an example. There are circumstances, because we always hear lie detectors are not allowed in court. Kind of. If both sides agree to the lie detector test, it can be utilized as evidence to the judge for belief pattern, et cetera. So it's not universal, but if this prosecutor agreed to such madness, to a statement being read, rather than enforcing the mandate, which is if you have evidence, including an eyewitness, and it may be the person who's charged as an eyewitness in the case, that person has to go through the scrutiny of cross-examination in order for the jury to properly have an examination of both sides of the evidence being presented. So I don't know how the hell that happened, unless they both agreed to it. Okay, we'll bring you updates as they come.